This was fascinating. The hospital did not dispute our version of the events of what occurred that ultimately led to my client suffering injury. But you know what they did dispute? They disputed what we call causation. They claimed that whatever they did not cause my client harm and injury. You want to know what this is all about? Come join me for a walk along the beach as I share with you the answers to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It was obvious from the start the defense was never going to be able to dispute our claim that they were careless. They were never going to be able to argue that the doctor who treated my client at this hospital departed from the standard of care. It was clear cut. Now, you would think after telling somebody, hey, listen, the hospital clearly violated the basic standards of medical care here, you would think that that's the end of the case. You would think that there's no place to go after that. The reality was they admitted freely that they violated the basic standards of medical care in treating my client. They basically threw their hands up and said, you know what? You're right. We have no defense to that claim. However, they turned around and said, but, and there's always that but whatever we did was not responsible for your client's injuries. They are trying to make a claim on causation, saying that there was no link between the violation from the standard of care, the improper medical care that my client received, and the injuries that she suffered while at the hospital. It's a very interesting strategy to take, and I'll tell you why. So in these medical malpractice cases in New York, we have to show three different things. We have to show, number one, that there was a departure from the standard of care, meaning that there was carelessness by a doctor or hospital staff. We then have to show that as a result of that carelessness, my client suffered physical harm and injury. That's number two. And we have to show, number three, that these injuries are significant and or permanent. And we are required to do all that using medical experts to confirm each one of those things. So now the defense is saying, look, you don't have to jump through hoops to establish that our doctor was careless and he violated the basic standards of medical care. We admit it. Okay, so we no longer have to worry about the first element in proving a medical malpractice case here. That's great. Does that mean we're home free and we can just go to trial? No, that's not what it means. Does that mean that the defense is going to roll over and start negotiating? No, that's not what it means. It means out of three different elements that we are required to show that we are slightly more likely right than wrong, we have now clearly established the first element. We still have to show elements number two. That means that causation. We have to show that there's a link between the wrongdoing and the injury, and we have to show that the injuries are significant and or permanent. Okay, so now the defense turns to us and says, listen, we don't believe that whatever we did caused your client harm. Your client suffered harm, the injuries that she's claiming, for a number of different reasons. Number one, she contributed to her own injuries. What they're really saying is she caused her own injuries. Number two, they're saying she had other comorbid conditions that exacerbated and made those problems worse because of her own actions. And number three, they're saying, listen, she would have suffered these injuries anyway, regardless of what our doctor did or did not do. Now, that's a very strong, compelling argument, especially when they claim they have a medical expert to support those arguments. Well, the way to overcome that is with our own medical experts. We have to have medical testimony, medical experts, establish that, number one, as a result of what they did or did not do, my client suffered the following injuries, and that her injuries did not arise because of anything she did, that my client's injuries were not preordained, that they were going to happen no matter what. My experts have to be able to articulate that she would not have suffered these particular injuries regardless of what the doctor did or did not do. And only through medical expert testimony can we now rebut the defense's claims. What happens next is now we go through the litigation process. And at the very end of discovery, after we have done all depositions, after we have exchanged medical records, now the defense turns around and says, listen, we're going to do everything possible to try and get your case thrown out thrown out before you ever get to trial, which means they are going to ask the judge in a formal written request called a motion. They're going to make a motion for summary judgment. It's as if we're having a trial, but it's being done on paper. And now they're going to make the same exact argument that I just told you about. They're going to say, listen, we admit liability, but that doesn't mean Oginski and his client are home free, and it certainly doesn't mean we're going to negotiate, because we feel that nothing involving this client's injuries, this patient's injuries, had anything to do with the wrongdoing that they claim we caused. So now they will put in evidence in the form of expert witness evidence to establish exactly what I just mentioned. Now they will have to support their argument with experts to affirm and to swear that there's no possible way this patient could have suffered these injuries because of this doctor's carelessness. And then in response, I now have to oppose this request, and it's called opposition papers, submitting opposition papers, with our own experts to detail and articulate and establish exactly why we believe that the defense experts are totally wrong. If the judge determines that there are material questions of fact that can only be answered by a jury, then the judge is going to deny the defense's request to throw the case out and allow us to proceed to trial. At trial, a jury will ultimately have to decide who is more likely right than wrong. Are we more likely right than wrong, or is the defense? So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.